Hello, everyone. My name is Nick Buonagurio, Senior Vice President at CanAm Investor Services, and I'm joined today by Mr. Christian Triantaphyllis at Jackson Walker. Christian, please tell us a few words about yourself and your firm.
Thanks, Nick. As mentioned, I'm Christian Triantaphyllis. I manage the business immigration practice at Jackson Walker. I'm based out of our Houston office, where we handle all things immigration, but we do have a very special, unique experience and very active EB-5 practice. We work with families from all around the world going through the EB-5 immigration process every day, from clients who are just starting out to clients who are finishing up the process and now applying for citizenship. So happy to be speaking with you today about some of the latest issues and concerns that we're having with our clients on a day-to-day basis.
Thank you, Christian. We're happy to have you. And, really, we're speaking today because since the Reform and Integrity Act was passed in 2022, the EB-5 industry at large has seen an increase in approvals in both legacy I-526 petitions and also quicker processing time for many I-526E petitions. And this is very encouraging for the whole industry and is really an exciting milestone for any investor when their petition is approved. But getting the approval notice is really just the first step. And we thought it would be very helpful for investors to do a deeper dive both into the consular processing for investors that are based outside the United States and also the adjustment of status process for investors based inside the United States. The preliminary stages for both are really the same. Obviously, an investor first needs to decide if EB-5 is right for them. If they do, they should certainly retain an immigration attorney as soon as possible to begin working on their source of funds and also begin speaking with regional centers to select a project. Once their source of funds is done, they can make their investment and proceed to file their I-526, now called the I-526E petition. And then they need to wait for the approval times. And again, we are seeing things improve, but it can take some time for the I-526E to be approved. But eventually, the approval does come in. And depending on where you are in the world, you will have a different process. So, Christian, let's first start with the consular processing for investors that are based outside of the United States. I guess as a starting point, how are investors notified that their petition has been approved?
Sure. So we'll get an I-526E approval notice. Typically, I'll receive that in the mail on behalf of my client, and we get to deliver the good news and then let them know that we're on to the next step through consular processing for those who are abroad. That I-526E petition, that approval notice, should be sent by USCIS to the National Visa Center. The National Visa Center is in charge of moving the investor through that consular processing step that I mentioned. So really, the news I'm delivering to the client is good news. Your I-526E approval has come in. Now this is your ticket to start your consular processing. We're now waiting for the National Visa Center to issue something called a welcome letter, a visa fee bill, which allows the investor and dependents to complete their DS 260 applications to start that consular processing activity.
Okay. And how long does it take for you to get that letter after you get the notice? So you get the notice via email, and then is that correct?
That's right. So I'll get the notice. It's sent to me by email.
Okay.
Now the timeline on getting that notice has been sort of differing between those who filed before the EB-5 Reform and Integrity Act and those who filed after. Those who filed before, unfortunately, have continued to be subjected to these longer timelines, I've noticed, where it's just been taking longer for the National Visa Center to issue us that visa fee bill. So I've had some clients waiting 6 months or even a little bit more for that visa fee bill. In comparison, many investors who get I-526E approvals tend to get the visa fee bill within a matter of 2 to 3 months after the approval. So it's really been a varying timeline. I can't say anything has been constant in terms of or consistent necessarily, but I have been seeing faster issuances by the NVC for those who've gotten the I-526E approvals.
Got it. So they receive the fee bill, whether it be in 5 or 6 months or sometimes 2 to 3 months. They submit that to who, and then what are the next steps for them after they receive that fee bill?
Yeah, so the next steps are to pay the visa fee online, and then we'll open up the DS-260 applications. So in the meantime, while waiting for that document, we'll be collecting other information from our client. Typically, we'll get some DS-260 questionnaires completed. We'll send out some checklists to collect civil documents for each one of the applicants going through the consular processing for their EB-5 visas. So
Okay.
once we fill out the online DS-260 applications, we'll submit those to the National Visa Center. We'll follow up by emailing each individual's civil documents, typically consisting of birth certificates, marriage certificate, copies of passports, police clearance certificates, things like that. We'll email those documents to the National Visa Center, and then we wait. We wait to hear back from the National Visa Center to find out whether our client is documentarily qualified. And we'll get notified that typically about 6 to 8 weeks later, with another email with a letter that says, again, good news, your client is documentarily qualified. If the National Visa Center determines the client not to be documentarily qualified, then they'll let us know, and they'll let us know what it is that we need to work on to get to that next step. So typically, we'll reach back out to the client. Oh, they didn't like exactly the way this police certificate was issued, or there was something problematic with the birth certificate. Let's get that corrected, get it resubmitted, and maybe in another week or two, we get that letter showing the client is documentarily qualified. And from there, the National Visa Center is going to work with the U.S. consular post where that applicant is from or where that applicant resides to schedule the EB-5 visa appointment. Now, that can take some time, though. That can take another 2 to 3 months for less, for those consular posts that aren't so busy. But some of the more common consular posts, think Mumbai, Guangzhou, Ho Chi Minh City, Ciudad Juarez, that's going to take some time as well. Could take 6 months, could take 9 months to get that EB-5 visa appointment scheduled. But we will get a visa appointment letter in an email to us once again saying your visa appointment has been scheduled. Here's the date and time. Please be here so you can attend your interview. During that time, the applicant and dependents need to go get their medical done. They need to get some biometrics completed. And each one of these consular posts sort of has directions on how and when to do this prior to their EB-5 visa interview.
So between waiting for your fee letter, submitting your documents, and then scheduling the actual consular interview itself, I mean, what would you say the range is? It seems like it's pretty wide. It could be anywhere from 4 months to another year.
Yeah, so that's right. So I do typically sort of try to prepare clients in terms of the timeline post I-526E approval of waiting anywhere from 6 to 12 months to be, attending their EB-5 visa interview.
Understood. Understood. And then when they actually go to attend the interview, what are they bringing with them?
Sure. So, we do send out some information about the interview, and they want to have their passport with them. They want to have their interview appointment letter. They may have their medical exam with them, or the physician may just send the medical exams directly to the consular officer.
Mm-hmm.
They should typically have their DS-260 confirmation page that shows that we submitted those DS-260s. It has some information on that the consular officer is going to want to see. Perhaps when entering the building, they're going to need to mention some information on that page. But that is mostly it. The rest of it, the consular officer is going to have in their hand. They're going to have a copy of the I-526E petition. They're going to see that the biometrics have been submitted through the consular processing process, and then it's time to take the interview.
And what are typically the things that are asked at the interview? My understanding is there's a pretty wide range of things that could be asked of investors. I know on CanAm side, just to prepare them from the regional center, we provide them with a very thorough packet that has all of their project documentation, their subscription documentation, all of the transactions of their funds going into the project, all of the project updates. everything they would need from a project perspective. But in your experience over the years, what is the range of questions that people are commonly asked at these interviews?
Yeah, well, that is a very thorough preparation of an applicant going into the EB-5 visa appointment on your part. I do put together a sort of a preparation document regarding the project. I tell the investor that they can be asked questions about the status of the project, sort of what's their role and the status of their investment. And that's very good that you're preparing them in such a way. I don't expect my client to know the full job creation number at that time necessarily, or the exact timelines of everything involved, but it's certainly helpful to have a good understanding of the status of the project and to speak confidently about job creation happening as a result of their investment. We also ask our client to go back and look at their source of funds narrative and documents that was included in the I-526E approval, because again, a petition, because again, that's what the consular officer is referring back to. And most clients have a very good understanding of where their investment funds came from, but we also do work with um, you know kids who received a gift, and made the investment, or somebody who's just not quite as familiar with the financial background from their family. And so we want them to make sure to kind of brush up on that source of funds information in case they're asked about anything related to that. But I also tell clients, don't be nervous about this. This is going to be a lot of questions about just yourself, pretty
Mhm.
natural answers that you can respond with. Where do you live? How do you support yourself? When do you plan on moving to the U.S.? Where are you going to in the U.S.? Who are you going with when you immigrate to the U.S.? And then these are going to seem fairly obvious answers because here you are, with your family members, and they're all listed on the application. But just answer them, truthfully. Short, concise is very good. They may ask about whether you're members of certain organizations that I'm sure you would say, oh, of course I'm not. But these are sort of the officer going down the checklist to make sure they're checking those boxes that they've asked these questions that they're supposed to ask. So that's sort of a short and quick version of how I would prepare a client going into an EB-5 visa interview. But it is sort of a combination of kind of the basics of the EB-5 petition, plus just making sure that you are who you say you are in that DS-260 application,
Mhm.
and the officer also making sure you are an intending immigrant. Like, let us know about your potential plans in the U.S. And it's okay if they're not set in stone. You don't have to have a full on exact plan on where you're going to reside. In fact, the directions in the letter say, don't sell all your assets yet. Don't think that you're already in the U.S. You've got to attend this interview first. Then you'll get your EB-5 visa and use that to enter the United States.
Understood. Great. Well, thank you for that. And so they make it through the interview. They walk out the door, but what are they given when they complete the actual interview? They're done with the officer. The officer says the interview's been well. You're moving on to the next steps. Are they
Sure.
physically given documents? What are the next actual physical steps? What are they given, and how do they proceed from there?
So they're going to receive their passport with their EB-5 visas in it. Typically, it's going to be mailed to a Dropbox location. They pick it up. They're also going to get an immigrant packet. That packet they'll travel with when entering the United States using their EB-5 visa and turn in when they enter the United States. And that packet will then essentially go to the USCIS so that USCIS can produce the conditional green cards. So it's sort of this combination of passport with EB-5 visa, the immigrant packet. There's going to be an immigrant visa processing fee, I think of $220 or so, that they need to go online and pay. And that's essentially it. Once they use the EB-5 visa to enter the US, I typically tell clients that I should receive the conditional green card within 90 days. That's sort of the timeline that USCIS gives us after an individual enters the U.S. Of course, if we don't receive it by then, we're then able to follow up with USCIS, ask where's the conditional green card. Sometimes they might say the client needs to come back in take biometrics, or we need to reconstruct the immigrant visa packet. Maybe there's some kind of issue that's come up that's preventing them from issuing that conditional green card. The good news is, if there is any delay on issuing the conditional green card, meaning it's not issued within that 90 days, and our client needs to travel, or maybe they have a job, they need to start once they get into the U.S., they do receive an entry stamp in their passport when entering using the EB-5 visa that shows their permanent resident status for a year's time while waiting on the issuance of that conditional green card. So they can use that entry stamp to work and travel as needed while waiting for the production of the conditional green card.
That's very helpful. And just to clarify one thing, so they're entering the United States with the visa in their passport, and they physically have a packet with them. When they enter the United States, their visa gets stamped. What are they actually doing with that packet?
From what I understand, they typically turn it in when they're entering at the airport, CBP.
So they turn it into the officers when you enter the
Yes.
United States.
Yes. Others don't get a packet. Kind of depends on the consular post, I believe, and it can all be done electronically. But we are still seeing, clients turning in this immigrant packet, and yeah, typically that's where they'll be turning it in, and then it makes its way to USCIS, and that's where some of that, I guess, link can get a little bit lost. If USCIS hasn't produced a conditional green card, we'll start to suspect, oh, maybe there's an issue with that packet being processed, or maybe the client hasn't paid the immigrant processing fee. So we just need to check back with them on that.
Understood. But typically within 90 days, they actually receive their conditional green card, which is the
that's the
two-year
much more common outcome. I get the green cards in the mail. I get to notify my client that, hey, we've got them. You need to come pick them up, or we'll send them to you. And now they've got their physical 2-year conditional green card in hand, and they've got all the same rights and responsibilities as any other permanent resident.
And what is typically the technical start date of that 2-year period?
It will be the date that they enter the U.S. using their EB-5 visa.
Excellent. So they have their 2-year conditional green card, all the rights and privileges of a permanent green card. Once they complete 21 months of that conditional residency period, they can proceed to file their I-829 petition.
That's right. And we'll be tracking those expiration dates, reaching out to our clients in advance to make sure we're preparing that I-829 and ready to file once that window of filing opens up.
Excellent. So now let's segue to investors that are in the United States and they're adjusting their status. So investors that are here on another valid visa class, an H-1B, an F-1, an L-1, various different types. Maybe we should just briefly recap, what are the benefits for people that are in the United States to concurrently file? We're certainly seeing high volumes of investors coming from the US, and obviously there's a reason for that. So maybe you can walk us through that briefly.
Sure, happy to. And this is something that's been coming up, this sort of discussion and explanation on this process more recently, and I've been a bit surprised because I sort of thought that the information was out there, but I'm finding myself explaining it again and again, which is always good to do because I'm delivering good news to someone thinking about this program. So under the EB-5 Reform and Integrity Act, we're now able to file the adjustment of status application alongside or concurrently with the I-526E petition. And what that means is we can not only just file the immigrant petition for the EB-5 process, we can also file the application that requests the issuance of the conditional green card at the same time. That's the I-485 application. With that application, we'll also submit I-765 application and an I-131 application. And these are for the employment authorization document and advanced parole travel document that an applicant can receive while waiting on the outcome of their EB-5 case. So this allows for the applicant or the investor to remain in the U.S. while waiting on the approval of their EB-5, even if their non-immigrant visa status expires, like an F-1, or they are laid off with, and they're an H-1B visa holder, or perhaps, someone's a E-2 visa holder and wants to sell their business or shut it down. Well, they no longer have to maintain that underlying non-immigrant visa status because we have filed the adjustment of status application with the I-526E petition. So not only does it allow you to remain in the U.S. Without being an unlawful status, it also grants you work authorization and the ability to travel internationally. Now that doesn't happen immediately. Typically, it's taking around, I'm telling people to expect a 4 to 7 month time period to get their work authorization and travel authorization. We have seen that be issued in a shorter time. For a few, it's also been taking a little bit longer. These are all sort of approximate timelines. But those documents are coming in a fairly timely manner, and they're typically issued in 5-year increments. So this is very good. Now, while you're waiting for your I-526E petition to be approved and your conditional green card to eventually be issued, you've got this ability to work and travel as needed. Children can go to school while their adjustment of status application is pending. So you really do have a lot of the perks that you're seeking ahead of time.
Yeah, we've been seeing this in very, very high numbers. So investors are filing all of these applications together, the I-526E, the I-485, the I-765, and the I-131. So they'll get their work and travel authorizations very quickly. In the background, they're still waiting for their I-526E to be approved, whether that takes a year and a half, or longer. Ultimately, the I-526E is approved. So they have the very meaningful benefits of work and travel within the first few months of making their investment and filing all these applications. Then they're still waiting for the I-526E to be approved. Once that's actually approved, what's the next step for those investors, the people that already have their work and travel authorization? Their I-485 is pending, their I-526E or I-526 was just approved. What's the next step for those investors?
Sure. So the I-45 adjustment of status application, that cannot be approved until the I-526E petition is approved. So you're not going to see the issuance of the conditional green card before the approval of the I-526E petition. So typically, I'm seeing the I-45 application then processed within another 6 months or so after the I-526E petition is approved. I have seen shorter, I have seen longer, but that is a kind of a general timeline I give people when they're asking me that very same question. And in that adjustment of status application, we're including copies of passports, we're including passport-sized photos, we're including a medical exam, and a lot of background information on each one of the applicants in the actual I-45 application. USCIS is capable of misplacing passport photos, issuing a request for evidence to resubmit those. In addition, while waiting for the adjustment of status application to be approved, the applicants will be called in for a biometrics appointment at an application support center. I typically don't see much of a connection as to when the individual goes in for their biometrics appointment and then the timing on the approval of the actual adjustment of status application, meaning when someone gets issued that appointment notice for the biometrics, and a client says, does this mean maybe in a week I'll get an approval of my adjustment of status application? No, I think their USCIS is just calling people in as they're opening up adjustment of status applications to get people prepped so that once the application is ready for adjudication, they've gotten that step taken care of, and now they can approve the application at a later date to issue the conditional green card.
And are there any action steps that the investor needs to take after the I-526E is approved? Again, and the I-526E is approved, and then they'll begin to process and approve the adjustment of status. You'll receive notification via email. Is there any action step that the investor needs to take at that point? Or are they really just waiting for the adjustment of status to be processed? It's still just kind of the waiting game with USCIS?
Yeah, for the most part, you are waiting now for USCIS to adjudicate the adjustment of status application. If you're beyond normal processing times, there are inquiries that can be submitted to say, look, I've got an approved immigrant petition. Why are we waiting on my adjustment of status application at this point? But there's not a need to now notify USCIS to say, hey, my immigrant petition's been approved. Go ahead and process my adjustment of status application. USCIS is handling that.
Understood.
There might be some, exceptions to that if we're using cross chargeability, where someone's spouse is from a country where they're not experiencing any kind of EB-5 visa backlogs, but the main applicant is from a country where they are. We might want to notify USCIS to say, hey, for this family, we're utilizing cross chargeability, so process everyone under the non-backlogged country, so you can go ahead and get to the adjudication of the adjustment of status applications. But that's a pretty nuanced reason to have to notify USCIS about this. The other thing I want to mention is, for the family to go through the adjustment of status process, the I-526E petitioner has to file their own adjustment of status application. And so I'm often asked, well, if I'm over here in my home country handling what I need to, take care of, I'll just file my I-526E petition. I don't want to file an adjustment of status application. I can't be in the US to take care of all of that. I'm fine to consular process my EB-5 visa. But I have children in university in the US, and I'd like them to just do this whole process in the United States. Can they just go ahead and file their adjustment of status application? The answer to that, unfortunately, is no, because if the parent is the primary applicant, the dependents cannot file their adjustment of status applications without the parent filing an adjustment of status application. So sometimes that leads to the following discussions. Well, one, does the parent really even want an EB-5 green card? And if not, then we might put the entire application in the child's name, who's at university in the US, so that they can go through the adjustment of status application. However, if the parents do want EB-5 green cards as well, what I'll explain to them is, look, we can, if you don't want to go through the adjustment of status application, we can either just file the I-526E petition, and then when the time comes to go to the EB-5 visa interview, your kids who are in school in the US can then accompany you to that EB-5 visa interview. And then you can all go to the US after that using your EB-5 visas. But some people are not comfortable with that either. So we go to the sort of next step of the analysis. Okay, fine. When your I-526E petition is approved, you as the main applicant, you can go to your EB-5 visa interview at the US Embassy. You'll get your EB-5 visa. You'll then use that to enter the United States. Your children who are in the US in an F1 student visa status, for example, can then file their own adjustment of status applications, saying that, look, my parent who's now in the US as a permanent resident with a conditional green card allows me to file my adjustment of status application so I can also be issued my conditional green card. So we'll do this process depending on what the family's needs are and where everyone is and what kind of non-immigrant status they have and what kind of obligations they have abroad as well, in order to accommodate each one of these families.
Understood. So there's obviously different strategic ways to manage different type of family circumstances, and that's why it's so crucial to work with an experienced EB-5 immigration attorney. So
Yeah.
Sorry, go ahead.
Oh, I was going to say, I would say not only that, I think one of the most pressing questions anyone's asking when it comes to these processes is how long is it going to take? And it's such a moving target. It can be that these timelines can be changing up every 3 to 6 months. So I think it's very valuable to be working with either one of our teams who sees these changes in timelines. We're seeing what consular posts are doing all around the world. We're seeing how USCIS is issuing work authorization and travel authorization documents, in addition to adjudicating the adjustment of status application. We're seeing these timelines in real time.
Absolutely. So the I-485 is ultimately approved. Are you notified again via email, or how are you notified of the I-485 approval?
Yeah, the I-45 approval we do receive that in the mail.
Physical mail. In
the physical mail. We'll notify our client. That's such good news, because now they are, on that day that the I-45 is approved, they are now a conditional permanent resident of the United States. And we can let them know that we should receive the green card any day now. Might take another 2 to 3 weeks to receive the conditional green card in the mail as well. and then that conditional green card, just like you described before, is valid for 24 months. And we've got to keep track of that expiration date and reach out in advance to prepare the I-829 petition.
Understood. And the start date of that 2-year period is the I-485 approval date. That's the
That's
start date
correct.
of the 2-year period.
That's right.
Excellent. And again, as you mentioned, then you'll be following the remaining 24 months, and the window to file the I-829 opens up at the 21-month mark.
That's right. And so, once it's time to get that stage done, we'll reach out and say, please send us some updated documents about yourself. And then, of course, we'll be collecting that job creation information from
Yep.
CanAm to make sure we've got the brunt of the I-829 petition taken care of. And then once we file the I-829 petition, just a reminder that the individual will be holding an expired conditional green card, but that I-829 receipt notice plus the expired conditional green card will demonstrate that individual's ongoing permanent resident status.
Okay.
We do send out the originals of the I-829 receipt notice because that's what CBP wants to see when somebody's traveling internationally and returning using that I-829 receipt notice and expired conditional green card. The copies are not going to be good enough. They want to see the the original of the I-829 receipt notice.
Okay, so what starts out as a 2-year conditional green card is extended while the I-829 is processing. So what's the term of that? You file the I-829 petition, and now your conditional green card is valid for what term, what duration?
Yeah, so USCIS has been adjusting that time frame again and again. Right now, it will say on the I-829 receipt notice an extension of 48 months
48 months.
while waiting on the adjudication of the I-829. And that really happened because it was taking the I-829s a long time to get approved because of these extended processing times. The good news is we are starting to see I-829s processed and approved in under a year's time, fairly consistently. Nick, you might be seeing that
Yeah,
as
and
well.
no, we have been seeing it, and I've been very pleasantly surprised. I'm still a little hesitant to set that as an expectation for a new investor because we all know for most of all of our careers, it's been closer to 2 to 3 years. So I
Right.
think going into every step of this process, I think it's always best to have more conservative expectations. But you're spot on. We're seeing more and more approvals in well under a year. I've seen some 5 and 7 month approvals, and it's very encouraging. We certainly hope that continues.
Yes, and then on the flip side of it, if for some reason the I-829 were to be processing beyond the 48-month time frame, the family needs to go in for an InfoPass appointment at a local USCIS office to get extension stamps in their passport showing that their I-829 continues to be processing. They still have the right to be here as a permanent resident, and that's a fairly routine process. It's just a bit inconvenient. So we do hope to see, and we are seeing the I-829 approved well before that at this point.
Understood. So in the hopefully rare event that it goes beyond 48 months, it can continue to be extended.
Yes, I mean it's such a clients get nervous. Well, what happens? Do I lose my permanent resident status? I want to be able to show, especially in this environment, that I do have a lawful status in the event I need to show my documentation. Um, so I am currently advising a few clients who are still waiting to go get extension stamps. And then of course they need to consider some other options to sort of force the issue because eventually it just gets too long and we have a valid reason to start pressing USCIS to adjudicate these I-829s.
Certainly. Out of curiosity, what is the term of those extension times beyond the 48 months? If you have to go for the extension, is that for another 48 months?
It's not, it's just for a 12-month
It's for
extension.
a 12-month extension. Okay. But they can continue to do that.
That's correct. That's correct.
Excellent. Ultimately, the I-829 is approved. The conditions are removed from the green cards. After getting, I guess, just to round out the process, after getting the I-829 approval, how long before they're actually issued a permanent green card?
Yeah, typically we'll get that I-829 approval once again in the mail, physically receive it. And we should expect to receive the green card, the non-conditional green card, within another 2 to 3 weeks. Typically, it's fairly fast, and so we'll hold on to the full set of approvals, and then we'll get the green cards in the mail, and we'll be able to deliver those to our clients as well. There's not much delay on issuing the green cards after the I-829 approval comes in. and that green card is valid for 10 years, just like everybody else's green card. It can be renewed just using a simple I-90 application after 10 years. And then in addition, an individual can apply for citizenship if they qualify to do so and want to do that. The time spent as a conditional green card holder goes towards that 5-year qualification period to apply for citizenship. So that sort of emphasizes that the time spent as a conditional green card holder really is time spent as a permanent resident. The difference is it's just that 2-year period on the green card versus that 10-year. And the way to extend the conditional green card is by filing that I-829 versus just a simple form I-90.
Great. Well, Christian, thank you so much for your time and your expertise. We greatly appreciate it. And I'm certain that the investor base does as well. And I look forward to speaking with you again sometime soon.
Thanks, Nick. I've enjoyed it and looking forward to doing this again. Thanks a lot.
Take care.